A few years later, in 2014-2015, I had the opportunity to second chair for the Internet and Mobile Association of India, IAMAI, in its writ petition before the Supreme Court challenging certain provisions of the Information Technology Act 2000. These provisions required online gaming intermediaries such as Facebook and Google to take upon themselves the task of deciding the legality of content posted by its users upon receipt of legal notices from third parties seeking removal of such content. The IAMAI's writ petition was decided in its favor as part of a batch of writ petitions in the landmark judgment of Shreya Singhal vs. Union of India, which is otherwise popular for striking down of the draconian erstwhile Section 66A of the IT Act. In the judgment, the Supreme Court recognized the chilling effect of overbroad restrictions on free speech. This judgment too remains a landmark one for its contribution to free speech jurisprudence, especially in the context of online platforms. While these cases certainly presented me with fantastic opportunities to apply my understanding of constitutional law to IPR and technology-related contexts and vice versa, my brush with constitutional law from a civilizational perspective first and truly began after I set up independent practice exclusively as an arguing counsel in June 2016. Fortunately, since I had earned my stripes as a litigator by then, my peers in the legal fraternity supported my decision, which kept me in good stead as an arguing counsel in civil commercial matters as well as in writ petitions before the Delhi High Court and the Supreme Court. It was around then that Senior Advocate Sri C.S. Vaidyanathan, one of the leading lights of the Supreme Court, recommended me to the team that till date steers the writ petition, the HRC petition, moved before the Apex Court by the late Swami Dayanand Saraswati. The HRC petition, which is yet to be decided by the Supreme Court, challenges the constitutionality of the key provisions of the Tamil Nadu Hindu Religious and Charitable Endowments, the TNHRCE Act 1959, the Andhra Pradesh Charitable and Hindu Religious Institutions and Endowments Act 1987, and the Pondicherry Hindu Religious Institutions Act 1972, the HRC Acts, for violating Articles 14, 15.1, 19.1g, 21, 25, 26, and 29 of the Constitution. The more I read the HRC petition and the material assiduously put together by the team in support of the petition, the more it convinced me that there was a clear causal link between state control of Hindu temples and the visible degradation of the temple ecosystem. Although I came to the jarring realization that a legal framework as invasive as the HRC Acts was reserved for Hindu religious institutions alone. I learnt of similar Hindu-specific legislations that were in force in Karnataka, Kerala, Odisha, and several other states. Given the significant questions of constitutional law involved in the HRC petition, such as the nature and role of the Indian state, its relationship with religion, and its treatment of religious institutions of different faiths, I was keen on contributing to the matter. I joined the team as an arguing counsel on a pro bono basis, which gave me the opportunity to work alongside eminent senior counsels such as Sri C.S. Vaidyanathan and Sri R. Venkatramani, who had been spearheading the matter from the beginning. Since I felt strongly about the issue, and there were several myths in the public domain as to who controlled temples and how, I delivered a few lectures on the subject within the broader canvas of civilization and the constitution. Coincidentally, it was around this period that I was approached by the trustees of People for Dharma, an NGO led by women, to present them as interveners before the Supreme Court in a writ petition moved by the Indian Young Lawyers Association in relation to the Sabrimala Sri Ayyappa temple. The writ petition sought entry of women of a reproductive age group into the temple as well as the removal of restrictions on entry of women into places of worship/prayer of other faiths as well. People for Dharma had previously launched a phenomenally successful international campaign called Ready to Wait on behalf of the women who supported the rights of the temple to protect its religious practices. I took up the case on behalf of the People for Dharma on a pro bono basis, since it presented me with an opportunity to showcase before the highest court of the land the sheer diversity of religious practices, the unique character of religious institutions within the dharmic fold, and the position enjoyed by the deities enshrined within. I also wished to highlight the rights of the deities and the devout under the constitution, and the serious complications arising as a result of application of non-Indic ontology, epistemology, theology, and jurisprudence to Indic ways of life, faiths, practices, and institutions. I presented these positions on behalf of People for Dharma before a 3-judge bench of the Supreme Court, which heard several others in the case. In October 2017, the bench referred the matter to a constitution bench, a bench typically consisting of 5 judges. By early 2017, the light of my involvement in the HRC petition and the Sabrimala temple case, the manifest incongruity of having to establish the legitimacy, authenticity and civilizational centrality of Indic or dharmic religious institutions before an ostensibly Indian court gave me the push I needed to understand the journey of the Indic civilization better. Despite a demanding professional schedule, I started reading the works of Pandurang Vaman Kane, Jadunath Sarkar, Radhakumud Mukherjee, R.C. Majumdar, K.A. Nilkanta Sastri, K.S. Ramaswamy Sastri, S.L. Bhairappa, R. Nagaswamy, Ram Swarup, Sitaram Goel, Dharampal, Kapil Kapoor, Koenraad Elst, Michel Danino, Shrikant Talageri, Meenakshi Jain and Sandeep Balakrishna, apart from the publications of the Ramakrishna Mission Institute of Culture and Bharatiya Vidya Bhavan. This was, of course, in addition to the writings of Swami Vivekanand, Sri Aurobindo and other civilizational icons. My reading was based on the recommendations of better informed individuals who worked full-time on civilizational issues as trained scholars, historians, civil society advocates, educators and public intellectuals. Also, the diversity of my reading was handicapped by the unfortunate reality that I was more comfortable consuming content in English than in Indian languages, which represented the very problem I hoped to understand better. On the constitutional front, I revisited the history starting from the Home Rule scheme in 1889 until the adoption of the Constitution in an effort to better understand whether this document captured the essence of and reflected Bharat's civilizational spirit. B. Shiva Rao's 6-volume publication, The Framing of India's Constitution, a Study, V. P. Menon's The Story of the Integration of the Indian States, and Justice Rama Joyce's Legal and Constitutional History of India, Ancient Judicial and Constitutional System, served as some of my principal references in this regard. I also read through commentaries on Bharat's journey towards constitutionalism written between 1933 and the late 1940s, which shed light on the history and the prevalent thought processes on the subject. This exposure enabled me to apply the lessons drawn from the literature to live constitutional matters. This exposure enabled me to apply the lessons drawn from the literature to live constitutional matters that had a bearing on the Indic civilizational worldview. Among them, perhaps the most significant was the Sabrimala Sri Ayyappa temple case, which was taken up for hearings in July 2018 by a constitution bench of the Supreme Court headed by the then Chief Justice of India, Sai Deepak Mishra. Fortunately, alongside several stalwarts of the profession such as senior advocate Sri K. Parasaran, I was granted the opportunity by the bench to present detailed arguments on behalf of People for Dharma and the Delhi-based women's organization Chetna, both of which supported the religious practices of the temple and its rights. This included its right to restrict the entry of women of the reproductive age group. Unfortunately, the Constitution Bench ruled in favor of the writ petitioners by a majority of 4-1 on 28 September 2018, against which several review petitions were moved. The review petitions were heard in early 2019, and later that year, acknowledging that the review petitions had merit, 7 questions of law were framed by a Constitution Bench headed by the then Chief Justice Sri Ranjan Gogoi and referred to a larger 9-bench judge. Pending the outcome in the proceedings before the 9-judge bench, known as a reference, when a larger bench is called upon to decide on questions of constitutional import, the next Chief Justice, Sri Sharad Arvind Bobde, declined to grant security to any woman of the reproductive age group who sought entry against the temple's religious practices and beliefs, thereby restoring the status as it existed prior to the first verdict. Alongside this, in the first half of 2019, in relation to the Sri Padmanabhaswamy temple in Kerala, I had the privilege of representing the chief tantri of the temple, the chief priest of the Chilkur Balaji temple in Hyderabad, and People for Dharma before the Supreme Court in an appeal from the 2011 judgment of the Kerala High Court. In its judgment, the High Court had held that the Travancore royal family had no authority over the administration of the Padmanabhaswamy temple after the abolition of royal titles and privileges by the Constitution, 26th Amendment Act of 1971. The High Court had also transferred control over the temple to a trust, which was to be managed by the appointees of the state governments of Kerala. Fortunately, the Supreme Court reversed the verdict of the High Court on 13 July 2020 and upheld the rights of the Travancore royal family as well as the authority of the chief tantri on religious matters in relation to the temple. My involvement in this case required me to understand, among other things, 1. The nature of Hindu princely states prior to their integration with the Indian Union. 2. The relationship between the heads of Hindu princely states and their titular deities. 3. The circumstances, terms, and conditions of integration of Hindu princely states with the Union. 4. The history surrounding the 26th Amendment to the Constitution. And 5. Of course, the recurring issue of state control of temples.